Okay, the first item we have on the agenda is to review the pursuant subdivision open space conservation easement. And put another copy in your folders. What I'd like to lead us through is are there any additions or deletions or things we would like to see in this? I would like to remind the board that this is open space that is set aside for our code so that the other homes can be clustered in a high-density subdivision. So, keeping that in mind, so does anybody in particular like to start with any of their comments? George?
I got a few.
Great.
You want me to start?
Yeah, please.
Okay. First thing I have is on page 1. A lot of this might be details.
That's all right.
Stuff, but I thought I heard in our conversation with Rob and people, it may not wind up being 27 parcels. It could be that there's, but I don't think there's going to be more or less, so should it be 27 plus or minus?
Could be. Perhaps. Am I going to release my tax returns? Maybe.
Or something along that line that it doesn't lock us into 27, is what I'm saying.
Yeah.
Would that be considered a weak yes?
No. I think what they're getting at there is that they want the credit. Okay, they want credit going forward. But yeah, the language itself, I don't foresee a problem adding that.
Okay.
We're rather wasting a lot of time discussing philosophy and all that. I don't think they have any objection.
Can I just address that? The references to the preliminarily conditional final subdivision approval with the date of January 7th, which was to divide it into 27 parcels. It's there for reference purposes. It doesn't tie you into 27 lots. It's just the name of that.
Well, that's what I wanted to assure.
Yeah.
We weren't tied into the 27.
Yeah, many times the recital paragraphs, anything that's labeled whereas is exactly that. It's a factual setup or recital.
Okay, at Thursday night's planning board meeting, if you remember, Rick Golden mentioned that the planning board has conservation easement that they use on a regular basis, and that we might want to take a look at the one that the planning board has.
Format.
Okay, and so is it.
I'm going to give my comments.
Yeah, in fact, George, just so you're right, I think Doug did do that.
I did.
Okay, right, yeah, so you were. Yeah, it's a template,
Okay.
It's,
Next comment I had was, in reference to the number 2, where it starts with A, B, C, D, and so on and so forth. It talks about specifics. I had a note here about there was no banning of storage of cars or trucks. And it's kind of pervasive through this, which bothered me a little bit, is there's a lot of stuff that's not allowed except if it is involved with agriculture. Mm-hmm. Right? And there's a lot of things that are involved with agriculture. And I just have some concerns about the fact that, they just would say, oh, that's agriculture. And I don't know, who knows what it could be. It could be a couple of trucks or something along that line. So I don't know how you tighten that up.
Yeah, well, just following that up, again, we're talking to the board. Isn't it the consensus that you consider this to be truly open space? You don't want to see any structures if at all possible.
Oh, yeah, it says that. Yeah.
Right, but what I'm saying is if there's any thought for a tower, above ground well or anything like that, you'd want to know about it or have it prohibited.
Right.
Correct.
Well, yeah, no, just elaborate, okay.
Yeah, but sometimes when you're farming, if I remember correctly, one of the open spaces that was purchased, and I forgot the name of it, across from Naruski, they picked out certain places where they would store hay and so forth. Now, they were going to put all these little buildings and
Slazinski
so forth.
also.
Right. Yeah. So, would that happen if they were to do that? well, these little, because it says no buildings, but then,
Right, arguably, and so that's what, that's what I was getting to in consensus, as to how tight you want it to be, and what your
this
true...
isn't very...
No problem.
Why don't we go through all the comments, and then we'll, because I think we're going to be a lot of redundancy, but we'll, conceptually, what if you would like to see this done? How would that go? George, go for it.
Yeah. Okay, again, the same thing about agriculture, but an access road would be allowed. And I could see that being a potential problem. That was on page 4.
I don't know if I got an answer on that. Is it prohibited or not?
Not specifically, but possibly by reading. When you go through them,
Okay.
Okay, this is something, I guess this is the legalese that I just didn't understand. It's page 5, the first paragraph. It says, talks about the conserved premises. Grantees exercise of or failure to exercise any right conferred by this conservation easement shall not be deemed to be management or control of the activities of the conserved premises. What does that mean?
I can tell you, I don't know if Robbie wants to address that, you want to make a note on it?
Why don't you answer the question beyond it?
Right, not a problem. Again, it has to be read with the other portion of the paragraph, George. The grantor shall be solely responsible for the upkeep, maintenance, et cetera, and shall have no obligation going on whatsoever expressed or implied relating to the use, maintenance, or operation of the conserved premises. Then the grantees, meaning you, the town, exercise of or failure to exercise any right conveyed or conferred by this easement shall not be deemed to be management or control of the activities on the conserved premises, meaning a forfeiture or it's the old story. If you do not exercise, it doesn't mean you continually in the future will fail to exercise. It's a one unrelated incident, if you will, and it doesn't say bind
everything up front.
Yes, exactly.
Okay.
B, under reserved rights, it says that including the right to engage and permit or invite others to engage. This is the grantor.
Right.
To engage in all uses of the conserved premises that are not expressly prohibited herein. I had a problem with that.
Yeah, it could be framed just in the reverse.
If we forgot to put something in there, then the grantor is allowed to do it.
Understood.
Well, when you're on that, can I just chime in on the exact same one? As you go along, it says any invitees. I'm not sure as far as the insurance responsibilities on the property. Do we have to maintain insurance on this property?
The grantor.
They will, because if they have invitees and they do, let's say, manufacturing of agricultural products, they can lease or hire in anybody to manufacture. You could have a full-blown operation on our easement, and that's the thing.
Right, as you'll see later on.
They're doing it themselves, well, I'm not sure if they're limited, but if they can invite someone to do it, they can get a firm.
Yeah, and by definition, anyone who's encouraged to come on the land is an invitee or licensee.
Right.
There's hold harmless and indemnification language coming in some affair.
The question along that same line, what Phil was saying was, is though, should we be named as an additional insured on their insurance policy?
Yes.
That isn't in here.
Under general policy, general policy liability.
Okay, next problem I had was Roman numeral 4.
As an additional insured.
They're not coming on the property.
But we're going to have enforcement obligations, inspection, baseline, And that's been the practice, I know, for the town.
It is.
Just so you're aware, And it's not a big deal. It's no cost to you guys.
Yeah, it doesn't cost.
Not at all. It's like a blank mortgage,
Then we go on to B, and it's Roman numeral 4, and it says engaging in or permitting tenants or licensees to engage in any and all forms of farming and agricultural operations.
Right.
Blah, 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 extension, and then it says, but not including, but not limited to extension of utility lines to conserve premises, drilling of water wells for irrigation. I can see that as a major problem. Digging of wells, affecting the neighbors, so on and so forth.
Neighbors are quite a distance from their
Yeah, many.
And farmers and agricultural, they need crops.
But you may.
I think when Why don't we, again, we'll go through what all the comments are and see if we can summarize them when we're finished, because I think we'll probably have some debate on these. Okay, George, whatever, Pat.
Moving right along here, I think I only have a couple of things left. Yeah, that was the last thing on that, but there were two comments I had made on the actual
Page.
this is the legal description.
Okay.
I note there that Mr. Henry Cirillo family is one of our neighbors. I think we've come across that name before.
Yeah.
So I think we should cross our T's and dot our I's.
Yeah.
Okay, who checks to see that this is actually correct? This actual
The description?
description.
We would take it against the planning board's records. They probably proofed this already, I'm assuming. And we would be checked against their records, the submission of maps, et cetera, and/or survey description.
Right, and then who files it?
Who actually filed this instrument?
Remember, I think we had difficulty with one of those things.
Oh, one of the Great Tower, the Great Tower case.
So, I just want to make sure it's filed,
Yeah.
and it's on record.
Yeah, most times, our general practice is now that we will file it with the applicant's fees, if you will, and/or it's monitored simultaneously with the applicant's attorney or petitioner. But we unfortunately, your office was involved in it.
Forgetting all that,
Right.
this conservation easement is not going to be filed, and I've said this before, it's not going to be filed unless this parcel is sold to this prospective purchaser. They are aware of it, and it will be filed contemporaneous with, simultaneous with the deed to that purchaser. That requires that the document be signed by your supervisor, by Mrs. Pursoon, and taken to that real estate closing. For those purposes, we would hold it in escrow and not deliver it nor file it unless the closing actually takes place. It would be given to their title company and filed simultaneous with the deed into the purchaser.
Right, but believe it or not, Robbie, not to be difficult, but as this board knows, that prior deed was to be held in escrow. It was held by another attorney. It was never recorded.
Then we would invite you to attend the closing.
I understand, yeah. Meaning it can be addressed. It can be addressed.
It's not meant to be adversarial.
I understand, yeah, it's going to be addressed.
Maybe it's our part more so than the grantor's part.
Yeah, even though the
Make sure all of them are filed.
Understand. Yeah, no, it can be addressed. It's not a problem.
Okay.
That's what I got.
Very good. Anyone else? All right, I've got some, again, I think for the applicants and for everybody here, the town of Goshen has purchased the development rights, I think, on 4 or 5 farms. 4. I've negotiated a couple of those. The whole board's been involved in these. And this is where we're taking taxpayer money and buying the development rights. And these were all farms. These were all open space. Right. And so what we try to do for our money's worth is the same thing that we have in our code relative to open space. And that is, even if it's an agricultural business, it can't do beyond what we have on this piece of paper. And here are some examples. Pursuant to what George said, but storage trailers and buildings. We've specified on our conservation easement, you can have a building here, no buildings here, one temporary building here, whatever it is that the person thinks they need to run whatever it is their farm would do. No wind and solar farms. You can't, so let's say they're organic farmers to begin with, and then 3 years from now, oh gee, we can't make it organic, let's put in 45 wind turbines or 17 acres of solar panels. Certainly removal of water to be sold to any other use other than what's on the farm. And we've negotiated this. Mineral rights of any kind, water and mineral rights. Because I think probably it does have a lot of water, and guess what? I think in time, may not be in our lifetime, but in time, water is going to be a very significant issue. And for all this open space we've had, we're trying to look ahead for what can or cannot be done. And Dennis, the associated ag business is pursuant to what George was saying in that one article. You know, anything deemed okay by ag markets, well, it's not what we want.
Understood.
Because you could put in a big warehouse to sell tractors, or repair tractors, or process onions, or whatever all these things are. And the code is for open space in perpetuity based on what we want. So we can cluster these homes as where they're at. And then what we also had in our we had a baseline inspection, and then we went on the property once a year to inspect it, building office.
Right.
In our case, it's the building office and the county, because the county helped fund those open spaces, just to verify that things, and the fact is, we've had no problems with the current owners. We think we might with the next generation or a third generator of owners, because they weren't here and didn't have any skin in the game when this was being put together, so to speak. So those are the kind of things, Dennis, that I think somehow need to be verbalized in this thing. So it's consistent with the other open space that we have.
Yeah, much of it can be done by, again, I can provide Mr. Dickover a template for
Right.
Don't you?
Hey, I've got a fundamental problem with what you're talking about.
Oh, okay.
And I'll just put it on the table right now. What you're describing is a negotiated purchase of development rights where you made a monetary payment to these landowners.
Right.
That is fundamentally different from your code requirement that space be dedicated for open space. When you start taking the person's right to, in those documents that we're all familiar with, where you restrict the right to put up a cell tower, you restrict the right to drill for minerals, drill for water, etc. You negotiated and paid somebody for those rights. That is fundamentally and soundly different than what's required for an open space dedication for clustering.
Dennis?
You have a great deal of latitude. I know what Robbie's saying, and
I know it's different.
Yeah, you can't point to it.
But this is what we desire.
Correct. Now, well, it also begs the question, because I don't know what the planning board went through in the process.
I have no idea.
Exactly. So, yeah.
But when I did go through there was one that we didn't buy. In fact, the one that I...
On the PDR, yeah.
No, it's not PDR. Come in, Jason.
Oh, you are on conservation?
Yeah, it was the one out on Craigville Road where they just came and gave it to us. And that's the one I compared this against.
I'm trying to think who you're speaking of.
I don't know.
My neighbors. They gave 47 acres.
Right.
What was it? Factory. Yeah, and if I may, there was a lot of prohibiting things in that contract.
Right.
I read it.
Yeah.
There was a K, no hunting.
Right.
No ATVs.
Right.
You can't walk on it. You can't do anything.
Right. Yeah. And we didn't buy it. That was just given to us.
Correct.
Another one was the Harold and Jean Jonas property.
Right.
They gave us the conservation easement. We didn't buy that one either, but it's very restrictive, and they said fine, and we go on with that.
This was a certain circumstances where the people were giving it to you voluntarily and giving you basically what you, quote, wanted, unquote. Here we have a situation where we're dedicating space for open space purposes to keep it in agricultural use. If you're telling me that you're fundamentally opposed to leaving this property for agricultural purposes, I think we're probably, I don't know, I hate to say it, but we're wasting our time here.
Well, maybe it needs to be kept for some purpose other than agriculture. We wanted open space when we put the code together.
Yeah, I have to hark back to, because I don't know what was done at the planning board level. I don't know what their concerns were.
But a certain amount of
The planning board attorney has seen this, I'm sorry,
Yeah, I assume he's seen it.
Council has seen this and approved it, so when we just came back to the note about the planning board format, I don't know why Mr. Golden would say that they have a format that might be different than this, and perhaps they do, but he has seen this and approved it, so I don't know quite
There must
where
be
that
a
might be.
standard format for everybody that's doing it.
Now, his format, some things were taken out of it.
Correct.
They're going to handle
So
every
this does not have
parcel
everything
different?
in it that was on that.
Yeah, that's why I say, I don't know what was addressed at that board. Because of the applicant didn't want it, or the board didn't want it, I don't know.
This is the open space that's dedicated because of the subdivision, is that correct?
That's right. Under the zone.
Every other subdivision, they have to dedicate so much as open space, is that correct? So normally, all of those conservation easements on that open space should be relatively standard because the code says you need to dedicate so much of your land, so much is developed for open space. Now, there are two things. We want to deviate from the normal open space that we've accepted from every other developer. But in addition to deviation, you want to deviate the time when you want to give us the open space and the requirements and the restrictions. So we're here kind of to accommodate you because you're not closing on the property. You don't have final approval. You haven't built. Primarily, that open space has nothing to do with the sale of one unit. You're asking us to do that to help move this along. Well, you're asking us to do it, and then you're imposing other restrictions or non-restrictions. I'm not saying it's right or wrong. I just want to point out that normally, when you get your final approval in this subdivision, starts UD with open source conservation, whatever. You want to do it before, but you don't want to do it until you close on that one parcel of property. You want to make sure if you sell the one parcel that you get credit for all the other open space. We understand why you're doing it, but that's not what's normally done. They don't normally sell one parcel of property in the subdivision and attach all that open space to that one parcel and upon closing of the one parcel. All I'm saying to you is we're trying to accommodate you. We'd like to find some level ground. So this is not adversarial. You have to understand.
I think I've had conversations with Robbie about this. Robbie, is there a problem with some of the factual or restrictive recitations they recited in terms of your plans?
What is
Because before you speak, because I think the board's not trying to overregulate. They're just trying to get to a point where they're comfortable with what they're doing and what may eventually someday show up on that property. That's basically the objection.
None of us will be here.
Probably not. Yeah, probably not.
What I hear happening is that this document's going to be basically thrown away, and we're going to end up with an open space conservancy conservation easement that's not been negotiated. It gives away all rights and ownership to the property except to go look at it and keep it pretty. We have a buyer for this property who's willing to buy it subject to this conservation easement, allowing them an agricultural operation, which should be, seems to me, consistent with this board's desire to keep this open space. If you can't use this agricultural, we all know it turns to woods in about 15 years. I don't know that that's open space anymore. Maybe it is, but it doesn't look as nice as a cultivated field.
Then again, your interpretation of agricultural use based on this, they can have manufacturing of agricultural products. That's not agricultural use. They can start a regular factory.
Well, it could be an agricultural use. It just may not be, definitionally speaking, the use that you find acceptable.
No, that's what I'm saying. His interpretation is, we understand that. If you want to make it agriculture, you want to plow it and grow stuff, yeah, that makes sense. And that's not what we're concerned about.
Well,
I don't know.
I don't know how you're reading it, that it will allow them to manufacture agricultural products, as in tractors and plows.
I didn't say tractors.
But you're saying agricultural products are...
If you're canning your agricultural product, you're growing it, canning it, or doing whatever.
So there's a prohibition against the construction of a structure. Typically, those kind of operations would need structure. So I don't know how you do that in a field.
Well, there's no structure allowed on the property?
No.
The structure is allowed.
Except as provided herein.
Yeah.
Except if it's an agricultural need.
Yeah.
If it's an agricultural need, then almost anything goes. So my concern was not to have this forever open. And your perception, Robbie, of what I'm thinking is clearly nowhere near what I'm thinking. But all I wanted to do was to tighten up the agricultural uses to a certain extent. I fully support the fact that it should be agricultural. I understand that. But just with some constraints so that really somebody doesn't take advantage of it. That's what I'm thinking.
Well, I think that we're going for some middle ground here. I think several of the things that I mentioned, like wind tunnels, solar farms, cell towers, or whatever, that's not agriculture. That could be just something we need to put in. Certainly removal of water and mineral rights, we have that. We don't want anybody selling water, because that ultimately is on all our properties we have that. The storage trailers in buildings, I guess, if permitted by I mean, I know with agriculture, for example, you can have a trailer for migrant workers. Well, you know, these are the kinds of things, depending, and I don't know how we get around those.
Yeah, I don't know if there's a specific concern by the applicant in those regards. I don't know, because again, I wasn't part of the planning board. I don't know what the intent is. I don't even know who the buyer is, you know.
Can I say, what happens, okay, we know, Bill John, agriculture's future in Orange County is not right. What would happen in 5 years, 10 years? That farm says something. Is that land always gonna be just restricted for agricultural use? The same period says that Sunday school to trees and marshes. I mean, we restrict a certain country as for agricultural use. I believe, yeah, we are open to. We had a few years ago, a guy wanted to bring in Jerry members logs and make wood chips. So that's an agricultural use, because the tree that grows, we bring it in, and Jerry members outside, well, we have big money. I'm just wondering what would happen to that piece of property if the farm, in a few years, just went belly up. So I can't make any money on this farm, I'm out of here. What happens to that land? Does it go to trees? Does it go to, or do we have to hope another farmer comes to say they want to farm there? That's, maybe I'm missing something. I am, please explain.
I would think if that happens, that scenario takes place, that farming is no longer, well, the person buys it and has all these wishes that they want to farm it, but they wind up not doing it. There's very little other uses that they can.
Well, that's why I want to make it clear, that parcel land from out here, conservation is just for farming agriculture use.
So you would be proposing then that it could be used for other uses?
No, that's what I want to find out, if it can be, all these, the other question is...
Just 3.6 on page 10, the encumbrance by the conservation easement, you know, parties mutually agreed will run with the land in perpetuity, et cetera. So it would have a severely limiting factor.
Okay, that's what when we had that, what was that group, the Northern Organic Fund, we went there in a meeting.
Marshall Ross.
Yeah, and then they just great, they went, and they just walked away. And
they were going to have a school,
Yeah,
related to agriculture, they were going to, you know, I don't know what all they're going to do.
Yeah, I just want to make sure in my mind that I know what the property will be used for in the future.
They were to endorse them for funding. We threw out on the table what we thought were our suggestions. I mean,
Are they done? I don't know.
I think so.
Let's just go to page 2, then number 2, sub B. We can add there that there won't be abandoned cars, vehicles, or farm equipment.
what page is that?
Page
Page 2,
2.
paragraph 2, sub D. Prohibit is the storage or dumping of trash items, and we'll add abandoned cars, vehicles, and farm equipment. And that should address, I think, one of the comments that someone made.
Well, what about storage trailers?
Storage trailers, fine, we can add storage trailers.
Okay, good.
It seems to me perhaps the exception might be unless being actively used in the agricultural operation. Because they do ship them out. You're going to have, you know, if this is, I think, a proposed cucumber farm, we're going to have trailers coming in to ship product out.
Well, to me, it would be more the permanent trailer storage versus the...
Versus the old box truck that's
Yeah,
up there to
you
store.
take the wheels off and just sit there and put your tools in it.
Right.
That kind of thing.
Trailer for hauling is a whole different thing.
Non-mechanized.
And the fact is, all you have to do is go on some of these farm areas around.
Storage trailers.
Yeah,
Unless being used.
Unless being used for transportation or whatever.
Storage, tools,
Oh,
and
well, I
equipment.
agree, yeah.
Okay.
You can do that.
All right, that's good.
The other was page 3, sub E, where you have the erection of any structures, including but not limited to buildings and fences, except as provided herein, for example, fences to support agricultural operation. I guess your concern is that you don't want cell towers and things that are not related to the agricultural operation.
I think maybe there's another one on here that, where it says the erection of billboards or other advertising displays, antennas, satellite dishes, solar, this is F.
Solar
panels, wind towers, etc.
solar panels, wind towers.
How about Little League signs?
Scoreboards.
How about municipal property?
Signs up on the,
Not related to you. It's another subject.
Okay, guys.
We're penalizing you, we're not doing.
One cucumber?
All right.
Okay.
We'll add those items there. You also mentioned page 4, sub J, buildings of roads or driveways except for construction of an access road to allow tractor accessibility to support the agricultural operation. That was inserted at the direct request of the prospective purchaser because they're going to need to put an access road into the field. That's all we're talking about. We're not talking about a road that will access other houses or any other property. It's just to get into the field.
Yeah, if you see this property, that's what they're gonna have to do if they're gonna farm it.
I know.
Okay.
You mentioned page 5, sub B, reserved rights.
Before we get into those.
He answered that question.
Oh, go ahead, I'm sorry, yeah, that's fine, okay.
That was page 5, sub D. I think Mr. Kaplicki answered your question about inconsistent purposes.
Yeah, and that, Dennis, is that what you're saying?
Yeah.
That kind of overrides what this is being said, because it says, you know, that it's not expressly forbidden, right? That it can be done.
Correct. You can frame it in the alternative, reverse it, if you will.
Such as?
Specifically, where are you, George? In B?
Page 5.
Grantor reserves to herself and her personal representatives, heirs, successors, and assigns all rights accruing from her ownership of the conserved premises, including the right to engage in or permit or invite others to engage in all uses of the conserved premises that are not expressly prohibited herein. You can reverse that and recite it that to engage in or permit or invite others to engage in all uses of the conserved premises specifically permitted hereunder. You know what I'm saying? You just reverse the emphasis. If it gives you more comfort.
Not here, they can't do it.
Correct.
Yes.
Correct. And I assume Mr. Bassoon and council would not have an objection to that, but I don't know. In other words, just reverse the emphasis to...
Well, we're all concerned about that portion. Notice we're all commenting.
And you use a separate paragraph, not be consistent with the purposes of this agreement. Those are descriptive.
Dennis, why don't you just pen something on that one so there's no misunderstanding what I think you have in every provided.
Including by example, but not limited to. Change it to simply that. Is it to address your concern?
Including by example. See, I think what the board is getting at is they don't want any wiggle room on these things. And if you use language like here, it's in the affirmative protecting the applicant, I think, in fairness, the board would want language in the affirmative protecting the town, that unless specifically permitted, it's prohibited, as opposed to, unless you prohibit it, we can do whatever. Follow? Okay, just the emphasis aspect, Rob, I think that's what they're going at.
Dennis, just pen something to make sure.
Yeah, I understand, yeah.
Okay?
Yeah, no, I don't force it,
Okay,
yeah.
that's fine.
Yeah.
Page 6, that item 9. That's one where we get into, I guess, the water and... Yeah, we have no problem with wells for irrigation at all. It's just selling the water.
You lost me, Doug. Where are you? 9?
Page 6.
Page 6.
Roman numeral 4. I'm sorry, 4,
I was
pardon me.
looking for 9. I couldn't.
He wasn't good in that.
That's the next
Yeah,
little
but you say 4, you mean IV?
Yeah, IV, that's
Okay. I'm looking for 4.
Nine is the next one.
No, it's what lawyers do, though. Picky.
I was gonna say, this meeting just started.
If we insert for you there, drilling of water wells for irrigation use on the conserved premises only.
Yes.
Yes, exactly. The emphasis being, exactly. What's specifically permitted.
Okay. Took care of that. Now, I do have a question, though, and I don't know, somewhere in here, Rob. Let's say that they decide, you know what, this isn't working. We just want to take all this black dirt and mine it and sell it by the truckload until it's gone.
Yeah, there is a prohibition. Yeah.
That's what
We have
happened.
code against that, I think.
State, you can't move.
It's also recited in there.
Okay, well, you answered my question. Thank you.
not only just black dirt, but just removal of soil, et cetera.
Right.
Into this,
Black dirt, not black gold, Supervisor.
Yeah, right.
Well, to the farmers, it's black gold, it's not a dirty dirt.
I can speak for the Polacks.
We have a big up.
Now, the other thing is that I still believe, whether we buy it or whether we accept the conservation easement, we have always had all the other properties, once a year, if we desire, to go on the property. Where is it?
Well, it has to do with the enforcement provisions, I suspect. 3.2 on page 8.
Page 11, 4.3.
Oh, yeah,
Inspection,
there
yep.
it is. Okay.
Oh, that's not one.
Yeah, that doesn't limit you to yearly.
The only thing I don't think we actually put into writing was the town being named as an additional insured.
Yeah, I think there is, I don't know if there was a specific insurance provision, Robbie. I know there's indemnification, et cetera,
No,
but...
there's an indemnification, but
Right.
nothing, it doesn't speak at all for the town being named as an additional insured.
That's just a general liability policy of insurance. I assume, I shouldn't say, but I assume that owner...
The owner will probably maintain their own liability.
Yeah, it's just a certificate of insurance. It's no cost, well, you know.
Far more.
Yeah.
Well, I guess the problem I have with it is that not all property is insured. Where you're imposing encumbrances on this property that really don't have anything to do with insurance and whether or not I have to carry it or not. It's certainly conceivable that, I'll say probable, that at some point this property will no longer be used for an agricultural purpose and it will go fallow. People will live in the house that's, on the other unconserved property and perhaps not insure this property at all. I think it's conceivable. I don't think it's fair to impose a burden on them to insure it for themselves and to have the town name. Not to mention the fact that you have an enforcement issue. Would the town really, try to, enforce that provision somehow?
Well, we don't have insurance,
police it,
that's
yeah.
on a lot of other properties.
Yeah, I don't.
see a reason for the insurance. We don't on other open spaces.
I think it's
They just probably addressed the indemnification whole.
Well, I mean, I'm thinking of one, for example, on Harold and Jean Jones' property.
Yeah, very possible you wouldn't
I
have.
mean, I don't know, it's just woods and...
The only thing, I agree with you on that, we don't see any reason, there's no monetary value involved in this.
There will be if it's naked. Ownership changes, they let it go fallow, an act of negligence or injury, et cetera, they're coming back to the town.
Well, that's the part.
And we got a hold harmless agreement against, I'm not sure who. But so, no, I'm not saying, I'm not advocating, I'm just saying that's, I'm sorry. I'm watching Five Faces.
I can answer your question, and I can do it for you.
Not a problem, I'm watching.
My thought is, if we have a conservation easement, right, but if we become additionally insured, I want to make sure that we're not roped into, by being a party to any type of insurance, that we're not roped into any liability claims or anything. That would, only because that just substantiates that we do have a vested financial interest of some sort, or we wouldn't be additionally insured, because all that means is when the check is written, we have to sign off on it. Well, if we have to sign off on it, I just want to make sure that they don't view us as, hey, part of, and so I just throw it out, so I'm not...
I think you're right. I think it drags you into the lawsuit.
I don't know.
It can.
That's all I'm...
You're not exercising dominion or control over this property. You have the right to walk on it, to inspect it. Beyond that, you're not managing it or owning it. I think you stay out of the insurance issue.
I think
You
you're
do.
absolutely
With great towns, where I was getting that from
Yeah.
was the insurance carrier basically saying when you're entering into some type of a contract,
Yeah.
you should have a hold harmless agreement, which is in there.
Correct.
And be named as an additional insured. That's where
Okay.
There's no asset in the owner.
And if a person didn't have insurance, I think you were alluding to that before, Dennis.
Go ahead.
If this went fallow, and then all of a sudden, there's no insurance on it, which I don't understand how that would be, because it's actually part of the property. That means, that would mean that a person would insure their home, and that small bit of 5 acres but then they wouldn't insure the...
It happens. They can walk away, a bankruptcy, a
Well, they
death.
could, but then
Yeah.
wouldn't that, who's left standing? It's us. But we're the only other party there. So
I can see them never building a house on that property. Grow their cucumbers. They're from downtown Brooklyn. They don't know squat about the cucumber business. She ain't gonna go. And they go back to Brooklyn, they own it, they pay the $420 a year tax on it, and it just sits there for the next 20 years. Their heirs try to sell. I mean, the fact is, it may not have any. Now, if somebody goes over and falls into the creek or whatever, I guess.
Yeah, that's all that concern.
Yeah, I bet.
But all we have
I don't know.
is an easement. We don't have any ownership on that side.
I don't think that they could. Do you, as an attorney, come back and?
Oh, I would try.
Well, I understand you would.
That's what attorneys do.
The question is,
Yeah.
if we were additional insured on the insurance policy on it, would you try harder?
It would certainly give me a pass. Oh, yeah, I'm
Sure.
not necessarily harder, but it would give you another arrow in your
More
quiver
gold
to
at the end of the
substantiate the
rainbow.
claim, hold you in.
Sure.
Yeah.
Yeah.
I don't know, board, I for one thing.
Yeah, because we don't have any ownership
We
interest.
don't have any ownership.
Yeah, you may want to stay away from that aspect of it.
Okay.
All right, 1, 2, me.
I still...
Okay.
Yeah.
4 and 1.
No problem.
Okay, very good.
We didn't need a vote on that, we just...
No, just,
A
there was
consensus.
a consensus, I didn't want to know what
We
everybody
go to the
said.
next one.
Okay, well, I'm going to conclude it then.
Yeah.
Did we get through it all right?
Yes, sir.
Now, Dennis, what's the path forward?
The path forward would be for Robbie to revise that along the lines you indicated. Get that to me, and then you can, I'll obviously run interference with the planning board just to check, there's no loose saying.
Now, do you, I guess in terms of your prospective buyer, of course, he'll have to see, or he or she or both will see all of this. and
Right, just so there's no
make a
misunderstanding.
decision based on what they see or don't see.
So there's no misunderstanding, like Robbie indicated. See, they want you to sign this now, and it's going to be held in escrow, because it may or may not come to pass.
Right.
I mean, it's in fact, exactly, just so you understand.
Okay, well, lead us through that so we know.
Not a problem, as soon as it would be revised, I would submit it back to you, and you could act on it as quickly thereon.
Fellas, thank you very much. Gentlemen, didn't mean to make it too difficult, but we have to grow on this together. Okay.
I don't want to see a John Deere franchise open up there either.
No, I
much to open up those.
I hope you do. I can't like
They run a 10K race.
Maybe you can make some kosher pickles out of the farm.
That was between you and I.
I got some Brooklyn.
You gotta go see the new business.
Oh, yeah. We may make it
A lot of people have a career and that's their relaxation and then they make a problem.
Now, do you eat cucumbers? Seriously? That's the way I would allow hunting myself, but for fear of getting the animal out. You want no farming, you want to be crazy with
On that land right there.
Oh, is that right?
They're handling all the other ones, this is just a partial.
That's right. I'm making a note to speak to Kelly about that.
Jason, we're gonna probably be,
How do you treat
another
those different?
30, 40, is that a problem? Okay. I'm sort of taking as long as it is, but we get wrapped around the axle. Okay, the next item.
You still get approved.
Okay,
Before you even go on, just very briefly, there's something to move about. What I'll do is I'll speak to the planning board, because going forward, there should be a standard format.
Absolutely. Right.
And, every applicant's different, but the sort of structure of these things, going with your philosophy, it should be the same.
Absolutely.
And I'm going to reiterate to them that going forward, you should monitor these things. So we wouldn't have to go through this each time.
This actually was authored by you, right?
Mr. Donnelly is in my office in cooperation with your planning board counsel.
Right, I've seen some of these words in your
Presented to this board.
Right.
A lot of it does dovetail.
Oh, yeah, great deal.
Okay. Thank you.
Okay, the next item on the agenda is review and approve a proposed memorandum of agreement with period of 12/31/2010 to 12/31/2012. This is with the CSEA. And Phil and I have been negotiating for some time with them. We had a meeting this past week, and this is a draft of the memorandum sent to us by their negotiator. Okay. And you can see, whereas the parties have engaged in negotiations in good faith in an effort to arrive at a successor agreement to a contract that expired on December 31st, 2010. The reason why that's over a year old is the negotiator became ill and was unavailable. And they've got a new negotiator working on it. And we've met twice and have come to this agreement. Whereas the parties have arrived at a tentative agreement covered by the period January 1st, 2011 through December 31st, 2012. So this is retroactive to January last year, and it goes to December of this year. Now therefore, is in consideration of mutual covenants contained herein, the parties hereby stipulate and agree as follows.
Hold on, Doug.
Sure.
This is a proposed contract that is not agreed to, it's negotiated.
Well,
This memorandum, they may have agreed, but I don't.
well, that's what I'm trying to get our board agreement to tonight.
And if we don't, all our negotiations have been disclosed.
Well,
we don't.
Well, I don't know.
Yeah, I would think, but I mean,
You may want to place,
what
I don't know what the status is, you may want to place it in executive
I would
session.
point out,
Well,
Okay, where I'm coming from, I don't want to be women.
well, we don't have to agree to anything, but I think that we do agree. We want the board to say why yea or nay, and so authorize me and Phil to sign this. Now, do we go into executive session and come out to do
Yes.
this? Fine, we'll do that.
That would be, unless you've already agreed to it, I'm not aware of. You know,
No, Phil and I have agreed to it, but the board has not agreed to it.
Yeah, you should do it in executive session.
Very good. The next item then is, accept Robert Lacar's retirement from the position of Deputy Highway Superintendent effective January 11, 2012. And we see in here, this is to inform the town of Goshen that I am retiring. My last day of employment with the town is January 11, 2012. Thank you, Bob Lacar. So, would someone make a motion we accept Bob Lacar's retirement?
So moved.
second.
Any discussion? Say that my discussion is, Bob, as we've all talked about it, to include his going away party.
Yep.
He will certainly be missed. He was a real asset to us for all the years of service, and I wish him the best. All in favor, say aye.
I just want to
Do a roll call.
I just want to talk my 2 cents about Bob, because I go too far back with him.
Yep.
As I told him, he's one of the grouchiest guys I ever met.
Really?
Let me tell you something. He had a job to do, and he did. In absence of our superintendent's help, you couldn't thank this man enough. He went well beyond job descriptions and admiration, all pats on the back, but he did his job. He did it well. His men respect him. I think he leadership. I wish him, with his health and his wife, the best of the years to come.
And to add to that, he was very respected by his fellow workers in the department.
I will send him a letter from the town board
Yeah.
We can do that.
for his
Sure.
his years of service. I think you want a roll call vote on this.
I used to go to visit him. He says, "What do you want? What do you want?" And
Do we?
he had no time to listen because
Actually, you don't need a roll call. By definition.
The reason I say it's on the resolution.
Oh, okay, yeah, no, that's an acknowledgement more than a
I don't see a...
Because a resolution
You're looking at your own resolution?
is self-effective. It's done.
all right, because I bet you Mr. Rowland's gonna listen because he has this Goshen.
All in favor, say aye.
Not to split hairs, because you have no control over the matter.
No, I don't.
If I resign, thank you, get your ass out. I'm sorry. But, you know, we don't have to do anything on a resolution.
You have to control yourself, Dan.
Anybody got a bar of soap?
Now, you do need a motion to send congratulatory letters, that's something different.
Yeah. Huh?
You do?
Why?
Because you do. You're being authorized by the board to take an official act. send a proclamation,
All right,
thank you. And that's the way I interpreted that motion,
Yes.
not accepting the resolution, the resignation.
I think you put him in timeout in the back for 2 minutes, so you can act.
Wait a minute, guy.
Go ahead.
What? We have, many times, because Doug, you send a letter, I've done it without a motion.
Yes.
The proper way.
All right, well, someone like to make a motion to authorize the supervisor to send Bob a letter of thanks.
Yes, so moved.
Second.
Okay.
All in favor, say aye.
Aye.
Good, we're covered.
Thank you, minus me doing it illegally, what was it?
It's not illegal, it's just a question of, proper.
Yeah, so-
I can get mad at Dennis now.
No.
Not us. You can't get mad at anybody.
All right, the next one, Dennis, help us with this thing,
Okay.
because I have a resolution, and then I have authorized the supervisor.
Right.
Can we do it in one, or need
You
two?
can, because the now therefore, the town board, town of Goshen approved the document entitled Town of Goshen Official Undertaking, as to its form and name, execution sufficiency to identify the town of Goshen. It should be an authorization in there to have the supervisor sign things. But what it would simply put, what it is, an undertaking is no different than a surety bond or a bond, if you will, protecting the event they should engage in improper acts. Anybody within the town who handles money, receiver of taxes, town clerk, etc., by law, when you take your oaths, if you will, you're supposed to file an undertaking. We do it by blanket purposes by one universal surety bond, I call it, which is obtained from our insurance company. And this is a motion which I believe Val modified from prior use or prior years. And the only difference would be in the now therefore paragraph, the addendum or addition, and that the supervisor be authorized to sign any all documents to effectuate the same. So it's a resolution approving the undertaking and authorizing the chief executive officer.
Would someone like to make a motion in this regard?
So moved. Second?
Any discussion?
Just kind of, that's why you all take your oaths of office. When you take your oath, it also recites you must file your undertaking. And that's the blanket, that's what this covers, because you fellows don't handle money.
Right.
Correct. Okay.
Madam Clerk, can we have a roll call vote, please?
Now we get the roll call.
Yes.
Councilman Caparino?
Aye.
Councilman Lyons?
Aye.
Councilman Newbold?
Aye.
Councilman Howard?
Aye.
Supervisor?
Aye. Motion carries, thank you very much. Now, what is, Dennis?
Does this one have to be acted upon now too, this whereas?
I don't know what you're referring to.
Next
It's a two-pager.
page, this is where we all sign it.
It says.
Oh, that is the undertaking. That's the universal document which is referred to in the resolution. Correct. And if you notice, it refers to all the elected officials. More than likely, you won't come into contact with any monies, but like the judges might. I suppose you might on some.
But these elected officials here.
Got to roll off George Washington.
Right.
All right, very good, thank you.
I have two in my folder, do they both have, is the one in a copy that?
I tend to think it's two.
Okay.
One.
Just not.
Okay. Does anybody else have anything for the open meeting? Someone to make a motion, we go into executive session then to, we have to do it in this order, discuss a police department personnel proposal, the MOA with the CCA, and a dial bus cost reduction review and negotiations with the intent not to return.
We have to return on this
CSEF.
No, we're gonna do that on Thursday.
Good.
Thursday.
All right.
That's it.
That's what I thought.
Okay.
So moved again.
Okay, all in favor, say aye.
Aye.
Motion carried. Who seconded that the first time?
I did. I did, I just.
Very good.
Because I think there wasn't something, was it?
Okay, Jason, we're gonna go to you next.
As soon as we get rid of the press. No offense, Neil, of course.
Yeah. Phil, just a comment. You know, Robbie's a good guy, but he was trained as a prosecutor. Well, he was trained as a prosecutor, and you got to understand, like your daughter, the mentality of attorneys is you always want the phraseology, if not specifically prohibited, I can do anything I want. Whereas the boards, so that's no conflict. You always want it like, no. You're only specifically permitted to do what we say. Everything else is prohibited. And that's what I think the underplay or counterplay was. You know?
Goshen, New York, Goshen, New York, Goshen,